papers are. Before we begin, I should remind everybody that the board proposes to make an anonymity order in this case, that no one shall publish or reveal the name or address of the child who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the child or any member of his family in connection with these proceedings.
May it please the court, I appear on behalf of the applicant and prospective appellant in this case. Appearing for the respondent are Ms. Keelan Gallagher, Queen's Counsel, Mr. Sam Jacobs, and also Mr. Barnes, an advocate of the Royal Court of Guernsey. As your ladyships and lordships will know, and might I just pause to say what a great pleasure it is to say ladyships in this court, I have only recently been instructed in place of Mr. Tom Richards.
Yes.
Late on Wednesday afternoon, in fact.
Well, we're sorry for the reason, but we're not sorry to see you.
Thank you very much. That's very kind. I've obviously been preparing assiduously over the intervening 4 days, but I can only apologise in advance if there are details of the case or the papers with which I am less familiar than I would like to be in normal circumstances. The anonymity or reporting restrictions order, of course, was the first order of the day. I'm very grateful to your ladyship for making that order. There is another issue which has very recently arisen. I think Ms. DeMambro may recently have mentioned that to you just outside court, my lady. On the way to court, walking there with the appellant, when I mentioned that we would be live streamed, he said essentially that that was news to him, and he was very unhappy about that. He thought that that would be precluded by the reporting restrictions order. He feels that people in other jurisdictions, in particular jurisdiction beginning with the letter A, to which we're not making reference in this case due to the reporting restrictions order, have previously revealed information that has been discussed in hearings in camera, and that has proved difficult to make those in other jurisdictions respect those sorts of orders. And for those reasons, he would like the hearing not to be televised. Now, I understand entirely how unusual that order is, and also that I am sure that the court would like that evidence, at the very least by way of witness statement. And with that in mind, I would ask that the hearing this afternoon not be live streamed, but that it be recorded so that it can be posted online subsequently. And this evening, we submit an application with accompanying witness statement to support the appellant's concerns. I've discussed this application with my learned friend, the limited one I'm making now, and they are neutral as to that limited application.
Ms. Gallagher?
We do have some observations on the issue. We do have concerns both about the timing and the substance of this application. My learned friend has said it's very recently arisen. It's arisen literally in the last few minutes. And the context to this is that, as you will have seen in the record, it was originally indicated that there may well be an application for this hearing to take place in private. And there was an exchange prior to Christmas where that was discussed. And our view very strongly was put that there was no proper basis for this to be in private. This court takes very seriously the principle of open justice, and we are very concerned that this has been raised in the way that it has and at the time that it has. My client, however, is strictly neutral on the request for the position to be preserved in order for the appellant to prepare his case and explain his reasons for the application. I'm conscious there may well also be some matters of concern, which indeed the registrar has just raised, about the logistics of this being facilitated at such short notice. And we're very conscious of that. But our position strictly is neutral in relation to today. I anticipate it's likely that we would oppose such an application if it were properly made overnight. But we think for today it's a matter for your ladyships and your lordships.
Thank you very much indeed, Ms. Gallagher. Ms. Derbyshire, we have discussed it. It is the absolutely standard practice of this court to sit in public and for its proceedings to be live streamed. That will have been perfectly well known to those who've been representing your client for some time now. And we see no reason to depart from that standard practice in this case. So we propose to proceed as normal. Thank you.
Next then, I have either Housekeeping, applications to adduce late evidence and a couple of extra authorities, or should your ladyships and your lordships prefer straight on to the issue of special leave, which is, of course, the first issue to be determined this afternoon?
Well, as to number one, we would prefer you to go straight on with the issue as to whether leave is whether special leave is required, and if so, should it be given. Secondly, we would require very considerable persuasion to accept evidence at this stage. We very rarely do. Thirdly, we don't need persuasion to accept further authorities. It happens all the time.
By way of evidence, I assume that your ladyship is referring both to the witness statement of Mr. Barnes and the witness statement of my client dated yesterday, so both witness statements.
There are two of them, yes. Yep. And we'll hear the application from the other side in due course. But let's get on with the meat of the matter.
I'm grateful. So by way of decision dated 8th of November 2017, which is at the back of the record of proceedings, second volume, your ladyships and Lord Reed decided that this afternoon should be devoted to the question of special leave. So that decision is at page 780. I should say that for our part, if permission were to be granted, we would of course be ready to progress immediately onto our substantive submission. Cross that bridge.
We'd be very surprised if it took the whole afternoon to deal with the question of leave. Very, very surprised.
First of all, there is the question of the participation of my learned friend in this afternoon's submissions. And in a nutshell, I'd simply like to set out the relevant dates and then leave it for the board to make the appropriate decision. In a nutshell, the issue is that the notice of objection was only filed on the 8th of January, in circumstances in which the notice of appeal was filed on the 5th of September, served on the respondent on the 6th of September, that's at page 755 of the bundle. A notice of objection should have been filed within 28 days of service. That's Rule 13. I've been sent by junior counsel for the respondent an email from the JCPC registry dated the 27th of November 2017, in which the respondent is told, "We do not expect you to file a Form 3 or to be considering paperwork until the position on representation is clear." And then I'm afraid I don't know the date on which representation was obtained. Certainly Mr. Barnes' law firm, ABT, has represented the respondent since February 2014. And there is an email to the court dated 19th of December 2017 about counsel who are currently instructed in the case having been instructed. So those are the relevant facts. I leave it to the court and to the board what approach you would like to take with those facts.
We'll be much more interested in the argument than we are in anything else.
I'll get on to the argument then, my lady. Might I first make a handful of preliminary observations about this case before addressing the first question identified in the decision of the 8th of November. So this case relates to a decision or decisions of the Court of the Seneschal of Sark, which order that the applicant pay the respondent periodic maintenance payments in respect of their child, whom we are referring to as C. Now, I've already adverted to the fact that I come new to this case, and so I can speak from direct experience when I say that at first blush, the merits of the case seem fairly dead against us. For a father to seek not to provide for and not to maintain his child seems a morally repugnant stance to take. However, that first impression is, if I might say, entirely misleading in the present case. The applicant is dedicated to his son. He's entirely happy to support him, whether voluntarily, as he was doing before these proceedings were brought, to the tune of €4,000 per month, or by order of any court with jurisdiction to make such an order, applying a law which provides for the making of such an order. Indeed, he has offered himself up under both a foreign law, which would do so, and the new 2016 law of Sark, which would do so. What the applicant objects to, and what I hope to show you in the course of my submissions he is right to object to, is the lawlessness of the orders made against him by the Sark court and on appeal. He says, rightly in my submission, firstly, that the Sark court has no inherent jurisdiction to make the orders, contrary to the pleaded position of the respondent and the views of, at the very least, the Royal Court of Guernsey. It has only its statutory jurisdiction, which relevantly is for cause en meuble. Secondly,
I'm sorry, Miss Wakefield, but we haven't... I thought you were going to deal with the question of leave first.
I am, my lady, but I hope to
You
make some
appear to be arguing the
preliminary...
case.
If the second or the third question arises in respect of leave, then my case is squarely in point. I can work through the questions as adumbrated by the court in the letter of the 8th of November and make these submissions when I come to them, though. I'll order my submissions then, as per the questions set out in the decision of the 8th of November. The first question is whether the Guernsey Court of Appeal has power to restrict appeals as of right in the way that it did. Section 16 of the Court of Appeal Guernsey Law 1961 is at tab 9 in the first volume of your authorities' bundles. It's on page 869 for those using the electronic bundles. And it provides as follows: no appeal shall lie from a decision of the Court of Appeal under this part of this law without the special leave of Her Majesty in Council or the leave of the Court of Appeal, except where the value of the matter in dispute is equal to or exceeds the sum of £500 sterling.
The short point really is that those words of exception, you say, exclude the Court of Appeal of Guernsey from imposing an additional and contradictory test.
Indeed, my lord.
Yes, and unlike the sister jurisdiction of Jersey, where the words of exception have been repealed, in Guernsey the states have chosen to maintain them.
Indeed. That's the short point, my lord.
Yes.
The Guernsey Court of Appeal refused the applicant leave to appeal. That's in volume 2 of the record of proceedings at page 746. And they did so in reliance on the well-known authority in Emerald Bay. We see that in the third paragraph, and they set out Emerald Bay in the cases which followed it. And then the sentence ends: the Court of Appeal may refuse leave to appeal to the Privy Council unless satisfied that the further appeal would raise arguable questions of general public importance of such magnitude that this court should give leave. So that was the test that they were applying. That was the gloss that they read on to section 16. And we say with respect that the decision in Emerald Bay, which that sentence accurately summarises, and the cases which followed it, is wrong. This is, I should note, common ground between...
Yes, we noticed that.
I'm happy to take the board to Emerald Bay, which is in volume 4 of the authorities bundle. At tab 53, page 2199. And in effect, in this judgment, the Guernsey Court of Appeal took notice of observations made by the Supreme Court in respect of Scottish appeals, and then in paragraph 7, it formulated and applied precisely the criterion applied by the court in this case, so a general public importance test. We say that this is wrong. We say it's an impermissible imposition of a criterion which we find nowhere on the face of the statute and which is directly contrary to the sense of the statute. It transforms a right into a discretion, and we say that that's wrong. I am supporting those submissions by the decision of the Privy Council in Lopez and Chettiar, which is in volume 2 at tab 19.
It might be said that one of the difficulties with the Emerald Bay decision is using the Scottish analogy, because in Scotland we had no such provision as Section 16 of the Court of Appeal Guernsey law to restrict the court's discretion as to the ground of the grounds on which an appeal could be pursued. Yes.
It's a completely open-ended discretion, isn't it, in Court of Session Act?
Yes.
Or was,
It
before
was,
before
it
it was
was
amended.
before it was restricted. There was simply there was simply a practice that council had to certify the appeal as reasonable, and so in support of your position, the analogy breaks down.
Breaks down in any event.
Yes.
Great. In Lopez and Chettiar, a similar provision governing appeals from the Federal Court of Malaysia was in issue. And we see that provision at the bottom of page 893 of the report, which is 1158 of the electronic bundle. And essentially, an appeal should lie from the Federal Court to the Yang di Pertuan Agong, which I think the Privy Council stood in the place of, with the leave of the Court, granted in accordance with the provisions of Section 75, and then A, from any final judgment or order in any civil matter where one, and then a valuation threshold, like in the present case. Leave to appeal had been refused in that case on the basis, and this is on the previous page, 891 or 1156 electronically, halfway down the page around E, just above F, for the reason that it would not be right to put the respondent to further heavy expense and inconvenience by giving leave, as the appeal appeared likely to receive short shrift in the Privy Council. Turning to the back page of that report, 894 or 1159 electronically, the Privy Council said that that was wrong. Between B and C, they say, in their opinion, Ratnam and Kumar Rasami, a previous case to similar effect, was decided on the right basis, and an appeal lies as of right in cases which come within A1 and 2, provided, of course, that the appellant complies with any order of conditionality, so security for costs and so on. Now, in fact, Lopez and Chettiar was a case where there might have been even more doubt than in the present case, because the word leave was in the relevant provision. And so it was thought that leave might import some kind of discretion. And of course, the word leave is absent from the formulation of Section 16. We are also supported by the work Privy Council Practice, authored by my Lord Mance and Jacob Turner, which is in Authorities Volume 5, tab 66. Para 3.10, this is page 2388 of the electronic bundle. It's the top of that page. In contrast, a local court is not entitled to treat the question whether leave should be given as of right as one of discretion, or to refuse such leave simply if it thinks that, and here we get to Lopez, it would not be right, therefore, to put the respondent to further heavy expense and inconvenience by giving leave if the appeal appears likely to receive short shrift in the Privy Council. Equally, the decision of the Court of Appeal of Guernsey in Emerald Bay to refuse leave as of right because the case did not appear to raise issues of any general public importance is questionable. And we say, with respect, it's more than questionable. We say it's wrong, and we say that it was an error in the present case for the Guernsey Court of Appeal not simply to grant us leave to appeal as of right.
Well, that appears to be common ground between you. And, of course, exactly the same question is already before the Privy Council in the Investec case. And so whatever we do say, we will say the same in each case. I'm saying no more than that. But, of course, Ms Gallagher does make the point that even if the Court of Appeal was not correct to impose that gloss, and should, therefore, not have done so, but it having done so, there is a discretion of sorts in this board to say, well, the case is so lacking in merit or arguability or whatever, that we're not going to entertain it.
Yes, my lady. If I might take you to Ross and Bank of Commerce, St Kitts and Nevis. So that is at tab 43, which is in Authorities Bundle 4. Sorry, that is a false reference.
46 possibly, Ms Wakefield.
I'm very grateful, thank you, my lord. Paragraph 6, the judgment of my Lord Mance, which is on page 1926. I'll read the whole paragraph. Where leave was not obtained for whatever reason from the local court of appeal, then special leave could still be sought from the Privy Council. Bentwich, at page 1110, describes the 19th century position as follows. Where the court below should have granted leave to appeal, the question in dispute being of the appealable value, but it has refused, a petition should be presented, addressed to Her Majesty and Council by way of appeal from such refusal, and asking that such order may be set aside and leave to appeal be granted. The position was codified in slightly different terms, better reflecting the terms of the 1833 and 1844 Acts, in a single set of rules by the Judicial Committee Jurisdiction and Procedure General Appeals. Rule 2 provided, all appeals shall be brought either in pursuance of leave obtained from the court appealed from, or, in the absence of such leave, in pursuance of special leave to appeal granted by His Majesty and Council upon a petition in that behalf presented by the intending appellant. Rule 2 of the 1982 rules, para 2 above, effectively reenacted this provision. Upon an application for special leave, if the Privy Council concluded that leave should have been granted as of right by the Court of Appeal, that would be a most material factor. But the Privy Council could, exceptionally, refuse special leave even in such a case, as, for example, where it was clear that the appeal was wholly devoid of merit and was bound to fail. And we see the reference there to the 2003 case, Crawford and Financial Services Institutions, which case is also in the Bible. And again, in that case, Lord Hutton said the Privy Council was not bound to grant special leave in such a case and retained an exceptional discretion not to do so. In my respectful submission, it must be correct that any such residual discretion should be very narrowly construed. That's because the simple point where the applicant has an appeal as of right, that right should be respected. And accordingly, it's only in very unusual circumstances, really in cases where the appeal is scarcely an appeal, and so falls outside the provision on that basis, which would justify the Privy Council refusing to grant special leave.
Ms Wakefield, of course, in the final paragraph, the board uses slightly different language, which you will have noted. It grants permission to Mr Ross. He should have had it below. And then the board says, and the proposed appeal is clearly arguable. The same words haven't been brought in from 6 to 19, but perhaps you say that they amount to the same thing?
I say that they amount to the same thing. Clearly arguable might indicate something a bit higher than exceptionality, but I would say that's wrong. It should be very limited, that discretion. And really, as I say, when the appeal is scarcely an appeal.
Well, I think you could say also that even if one had said in paragraph 19 is strongly arguable, all one would have been doing is saying that it meets a higher standard than is required. We certainly don't address this precise nuance between arguable and wholly devoid of merit, and there may not be a huge amount of difference, it seems to me, ultimately, if you conclude that something's unarguable.
Well, it's one paragraph that sets out what the test is, and paragraph 19 sets out what the conclusion is. Yeah. I think that's the point my Lord is making.
Yeah.
It clearly overcomes the hurdle. It's wonderfully arguable.
Yes.
Fantastic
Right.
case. Yeah.
However, it is true that the Privy Council in Crawford said, as for example. So I think it's one of these cases where perhaps it's better not to try and legislate for everything.
That may well be the position, my Lord. I take that entirely. I think the idea of exceptionality, and the idea that, in essence, right of appeal, which is unconditional, should be protected, is the critical one and the thrust of my submissions. The respondent submits, unsurprisingly, that this is just such an exceptional case where no special leave should be granted. We say that submission is hopeless. We say we are very far away from a case in which an appeal is wholly devoid of merit and bound to fail. At this point, I may take up the submissions which I foolishly tried to launch myself upon earlier this afternoon. I'd already, I think, covered my first ground of appeal in respect of jurisdiction of the Sark Court. The second point relates to our conflicts argument, ground 2, and that's when the Sark Court considers a cause en meuble, it has to apply the ordonnance, which says les meubles suivent la personne. So they should have applied, as a matter of applicable law, the law of the domicile of the respondent. Obviously, there were immediately in something of a hypothetical world because the summons relied on the court's inherent jurisdiction, not the cause en meuble, but we say the only available jurisdiction of the Sark Court was cause en meuble. My third ground of appeal is if we are within the court's jurisdiction and Sark law, rather than the law of the domicile of the respondent, does apply, there is in any event no action for maintenance known to Sark law. Now, I will, if I'm allowed to develop my submissions and granted leave, rely in particular on the effect of an 1583 order in council to that effect. I'll rely on the effect of the approbation des lois by virtue of the principles in Snell and Beadle. I'll rely on the absence of any convincing evidence of a customary law right developing in the intervening 430 years. And I'll rely as well on the fact that the Sark legislature, the chief pleas, was at this particular moment in time seized of the question of what to do on this topic. I will be showing this board, if I'm allowed to do so, a 2008 Guernsey and Alderney law which deals with this very topic, which Sark did not sign up to, with Sark instead enacting its own law in 2016. So that straddles the period in this case. The summons was issued, if that's the right terminology, in 2013, 2008, 2016. The legislature was seized of this very issue. This, together with the fundamental lack of certainty when it comes to crafting a cause of action, even assuming that the obligation could be read into customary law, means that the Morton and Paint criteria for the development of customary law in the Channel Islands were not met. Even if your ladyships and your lordships are against me on all of those points, jurisdiction, applicable law, and content of law, my fourth ground of appeal relates to quality of law. Now, we put this as an A1P1 point, and I will be saying that these payments fall within contributions in the second paragraph of that article. But in any event, we say that these are general rule of law and Morton and Paint points, that the law lacked accessibility and certainty. And finally, I'll be addressing the board, if I'm given leave, on the interim payments that were ordered with no specific statutory authority. So those are my grounds of appeal. I say each and every one of them is more than arguable. I say it's destined to succeed.
Well, you would say that, wouldn't you?
I would say that. I would say that.
Could I just ask you one thing about your second, which is the applicable law point?
Yes.
Because the Court of Appeal, at paragraph 24, says that you're not entitled to pursue that.
Yes, so they say we're not entitled to pursue it because they think that it was determined below and it was held not to be relevant. That's applicable law in respect of the legitimacy of the child. So there was an argument about which law should determine his status. And ultimately, the Seneschal said that didn't matter. This is a different applicable law argument. This is about the law which applies to maintenance obligations. Now, my learned friend will say that I can't take that point because it's not been pleaded.
Because you didn't take it below, yes.
Of course. And I say that's wrong because the summons was a summons relying on the inherent jurisdiction of the Sark Court. So, of course, we didn't respond to that summons by saying, do you know the applicable law which applies to an action that's a cause en meuble is that the meubles suivent la personne. That wouldn't have met the claim that was against us. They pleaded a claim in an inherent jurisdiction. We're saying that's the wrong jurisdiction of the court. And this has come out as the case has gone higher on appeal. But patently, we couldn't have been required at the time of lodging our defence to say the applicable law to a cause en meuble would be the law of a domicile when that wasn't the originating summons we were meeting. who are meeting a claim by virtue of the jurisdiction parens patriae. So I say that's a bad point.
Thank you.
My learned friend sets out 5 reasons in particular why she says exceptionality is met in this particular case. First of all, she says that the position that there is no action in maintenance in Sark law, there was no action in maintenance prior to the 2016 law, is of dubious public interest and has no reasonable prospects of success. Well, I've dealt with prospects. Public interest, we think the existence of or non-existence of a right in maintenance is of public interest.
In any event, I mean, your primary submission is general public interest isn't the test.
It isn't the test, exactly.
So you say
Can't be read back
you
in.
say you've got an appeal of right. You can't bring it back in by the back door.
She also says the point is academic. Again, your lordship reminds me to keep on applying the relevant test. Being academic wouldn't be enough in my submission. And the reasons why she says it's academic are thanks to the 2016 and 2017 laws. Now, the 2017 law, which is, as I understand it, to do with orders of affiliation, isn't yet in force in Sark. And the 2016 law, it's true that parental responsibility could be assumed by the applicant under that law, and indeed he'd be willing to do so, but that has not happened. In any event, the short point is that that does nothing to cure the defects of the judgments against which he appeals and the orders which presently bind him. And it would be unacceptable to say, in reliance on the 2016 law, which has not been applied to him, that he is stuck with unappealable, unlawful orders which do bind him.
But is it in any event academic for the applicant if there are arrears due under the orders made?
Well, one of the orders under appeal is the order enforcing the arrears, isn't it?
That's one of the orders under appeal, yeah. Of course. So it has real financial consequences for him in any event.
Which were made before the law, before the new law came into.
Absolutely, yeah. 3 years before the first one.
But if he's willing to make the payments anyway, is the argument simply that he's not willing to make them in the sums ordered, or what?
Well, he's not willing to make payments. It's not a question of the sum to core. It's not that that's the problem. It's the way it was calculated. It's the cause of action. It's that he wasn't in breach of any obligation because he'd been paying €4,000 from the off. And depending which applicable law is applied, those are material considerations. There's also, of course, the quantum, and one of the other possible applicable laws, the law of the respondent's domicile, has essentially a tariff system, so for the first 3 years of the child's life.
Yeah.
So a very different approach would be...
Yeah, so it is basically quantum.
It's not purely quantum, no, my lord.
But you say,
Well, he was, if I
you
could
say
just...
he's been paying €4,000 a month.
He was, yeah.
Does that not exceed the order of the court in terms of quantification?
It vastly exceeds the order.
Why are there then arrears an issue at all?
So there are arrears. He paid €4,000 a month until the time of the summons, and then didn't comply with the court order. So arrears built up pursuant to that court order.
I see.
So he stopped paying once there was any question of his being legally obliged to do so.
Not once there was any question of his being legally obliged to do so, but pursuant to a court order which he believed to be unlawful.
Yes. So the reality, contrary to what was said beforehand, he's not voluntarily giving €4,000 per month. He did until there was a court order.
He did until 2013. I hope I said that. It was certainly in my speaking notes to say until 2013.
So I hadn't picked that up.
No, I certainly hadn't picked that up.
And what's he been paying more recently?
Just take instructions.
Thanks.
So a final order was made in 2015 of 1,800, and ever since that point, the appellant's been paying 1,800 every month plus 1,200 to clear clear their arrears pursuant to the interim order.
He's been paying 1,800
So
It's
£1,800
pounds per month.
Yes,
Well,
plus
that is the current order.
that's the current order.
So that's not discharging the arrears at all.
No, plus an additional £1,200.
1,200.
Oh, I see.
So-
I didn't hear that. Forgive me.
So it's 3,000 a
3,000.
month in effect.
3,000 a month.
Thank you. But there are still arrears, therefore it's not academic. Thank you.
And the third reason given in paragraph 15 of my learned friend's written case is that the appeal is said to be academic prior to the 2016 Act, because the Royal Court of Guernsey, to which the respondent would have had recourse, did have jurisdiction to award maintenance. I have to say, I'm not sure that's right as a matter of applicable law. So the Royal Court does have jurisdiction to make maintenance awards and does so pursuant to Guernsey law. But of course, when the Royal Court of Guernsey hears an appeal to which, or a first instance proceedings to which Sark law applies, it applies Sark law. So although that would get over jurisdiction, it wouldn't actually get them all the way home. Fourthly, my learned friend rightly recognises that the applicant's arguments in respect of the jurisdiction of the Sark court are significant. So were one to be applying a general public importance test, which one is not, they would meet that test in any event. Indeed, she characterises them as, if successful, bringing about a radical change in the understanding of the Sark court. These arguments are important and we say deserve to be determined by this court were that to be the correct test. Finally, she says simply that this appeal is further protraction of the present litigation. Of course, that's true, and it's right that both parties, and indeed all of us here today, should have the child uppermost in all of our minds. However, reliance on this as a ground to shut down the appeal would, we say, be entirely wrong. The final point, which is very fairly recognised by the respondent in her case in paragraph 17, is that we are all here today and ready to go. Now, I'm not sure what the correct legal packaging is for that submission, but as a matter of real-world practicalities, much time, energy and cost, including to the Guernsey Legal Aid Service, has already been spent on preparing these substantive arguments. And so in those circumstances, again, whatever test were to be applied for the grant of special leave, we say we're not within exceptionality or any other test.
Well, I suppose a few provisional conclusions might be drawn from the amount of time that we listed this hearing for.
I wouldn't dare to draw any conclusions from that, but I have. I'm free tomorrow and the day after.
Ms. Wakefield, has this litigation about money for the child delayed the court's consideration in Sark of the other substantive issues relating to the child, and if so, why?
I'm told that maintenance has been split off from the other issues that the court was considering, but they've progressed in parallel. The parents currently have shared residence of the child, so I don't believe it has delayed any ancillary matters.
Well, I mean,
These parents have been litigating since 2013 about a very young child, and the basic dispute is about where that child should be permitted to live. That's the basic dispute. Those of us who deal with such cases in this jurisdiction would find it quite astonishing that we have got to this stage without that basic dispute having been litigated in the best interests of the child. And we cannot understand how that has happened.
And it's true, my understanding is that he is not allowed to leave the jurisdiction, the island.
Well, am I right? I'd like to know the answer to this, that the current order governing matters is that which was made in the Royal Court in December 2013.
Which is the page?
Yes, my lady, you're right.
Yes, it's at page 383 of part 1 of the appendix. I don't know what the electronic page number is, but that gives the current situation.
Yes, my lady, that's right, that's correct. My lady, on special leave, I've dealt with question 2. Question 3 was if the Court of Appeal does have the discretionary power that it believed it had, whether the board should nevertheless grant special leave because the test for granting special leave in a normal civil appeal is met. Would the board like to hear my submissions on that?
Well, you more or less have made your submissions on that, haven't you? Yes. In making your submission that it's certainly not hopeless, you've also made your submission that it does involve some points of law of general public importance.
Much like paragraph 6 and 19.
Yeah.
I've cleared the hurdle.
Yeah. Yes. Well, I think you've probably dealt with that, and
I'm grateful, my lady. Shall
we
I?
better listen to Miss Gallagher.
Thank you, my ladies and my lords. If I can start by saying that we're very grateful, Lady Hale, for the reference that you've made just now to the procedural morass and the length of time that this has taken to get to this stage. You will have seen from the outset of our case that we've highlighted our concerns, and indeed, Lady Hale, you referred to it being quite astonishing in this jurisdiction to see what has happened. You will have seen the remarks of the Court of Appeal of Guernsey, who also considered it to be quite astonishing and raised very serious concerns. In terms of the issue of special leave, I can be very brief. On the timetable, we'd suggested 30 minutes. I can indicate at the outset I can be much faster than that, and I hope that's of assistance. We're certainly not in the business of engaging in procedural point scoring. We want to get on with it, and you will have seen pragmatically in our case that we acknowledged in our case that the Privy Council Judicial Committee may well be of the view that we are where we are, we're here, and it's listed in the way that it is. So the submissions I make now are made very much against that pragmatic backdrop. So there were 3 issues identified in the letter from the Judicial Committee of the Privy Council to the appellant, dated 8th of November. I don't ask you to turn it up, but for your note, it's in Record Volume 2, page 780. It's the final page in the bundle, and it's MS 780 as well. And those 3 questions were, firstly, whether the Guernsey Court of Appeal has the power to restrict appeals as of right in the way that it did. Our answer, in short, is no. And that's now common ground. The Court of Appeal was wrong to refuse leave to appeal for the reasons that it did, and that is accepted. This also means question 3 falls away. So the critical question becomes question 2. If the Court of Appeal does not have such a power in the way it expressed it, whether on the merits of this case the board should decline to cure the defect by the grant of special leave. And in our submission, the grave degree of uncertainty in the authorities regarding precisely what the test should be in deciding this question is an important reason why, regardless of whether the Judicial Committee wishes to proceed to hear the full substantive appeal, it would be very helpful to have some clarity about what the test is.
I think you're probably exaggerating at the least to say there's a grave degree of uncertainty as to what the test is. We've used the test in Crawford and Ross repeatedly in practice, and I suspect it may appear in some of the answers to permission to appeal applications, but it's certainly the one which is applied on a daily basis. There may be nuances at the edge as to whether something is sufficiently arguable, but basically, if it looks hopeless or without merit, it's not going to get leave, even if it should have been given it as a right.
I think we're a little at cross purposes, my
Yes,
Lord, Lord Mance. I very much do agree that the position in relation to the Judicial Committee of the Privy Council and what test should be applied at this stage is relatively clear, although there is some doubt, and I'm going to come to that. There is much more uncertainty when we look in the Guernsey courts about what the Guernsey courts should be doing. And there is an important issue for this court to clarify in those circumstances, and I'm going to come to that. So what I was intending to do do was to make very brief submissions on the test to be applied, both by the court below and then also by the Judicial Committee when considering an appeal in these circumstances where leave has been refused, albeit it being, although it's a situation where there's an appeal as of right, and then application of the test in this particular case. And on the application of the test in this particular case, I will be very brief, but I will be drawing in particular on a question which was asked by Lady Hale in relation to one of the grounds of appeal in relation to conflict of laws. So if I could start with the test to be applied, there are two different questions: the test which should have been applied by the court below, and then the test to be applied by the Judicial Committee in determining this application. And there's certainly greater uncertainty about the first of those limbs, Lord Mance, although there is some uncertainty also about the second of those limbs, about the test to be applied by the Judicial Committee. And it would be extremely helpful if we could get clarity on both of those. So in respect of the Court of Appeal of Guernsey, could I ask you first to look at the record volume 2 at MS 746 at paragraph 3. This is where the Court of Appeal followed the approach adopted by the Court of Appeal of Guernsey in the Emerald Bay case in January 2014, which I'll come to in a moment. And importantly, as acknowledged in paragraph 3 there, it had since been followed by the Court of Appeal in 3 further cases. So the Court of Appeal, in that short decision at page 746, was following what is now a settled line of authority in Guernsey. It was the 5th of a series of cases, the first one of which was the Emerald Bay case. Now, we're conscious, of course, that Emerald Bay was argued before the Judicial Committee. It hasn't been the subject of a published decision as yet. So at the time when the Court of Appeal approached this, it was operating in circumstances where there were 4 Court of Appeal cases which purported to establish that, notwithstanding the terms of Section 16 of the 1961 Act, the Court of Appeal may refuse leave to appeal to the Privy Council unless satisfied that the further appeal would raise arguable questions of general public importance of such magnitude that the Court of Appeal should grant leave. Now, this wording, we're agreed, would convert an appeal as of right to something much more akin to the rule applied by the Supreme Court, for example, when considering applications for permission to appeal from England and Wales or Northern Ireland, or a variation of the very common formula in jurisdictions in which their local courts of appeal have a discretion to grant permission to appeal to the Judicial Committee of the Privy Council, as reflected in Practice Direction 2.1 and detailed in great detail in Chapter 3 of your book, Lord Mance. Now, both sides agree that that's not the correct test, but it is important to acknowledge that the Court of Appeal in Guernsey here, in 5 successive cases, has expressed the view that Section 19, interpreted in the manner which both parties now submit to you it should be interpreted, is not appropriate for their jurisdiction. And the Court of Appeal's view in this regard in Emerald Bay was substantially driven by respect for the workload and pressures which the Judicial Committee and indeed the Supreme Court are under, and by the views expressed by both the House of Lords and the Supreme Court in 2 Scottish appeals. And could I ask you just to look at Emerald Bay itself? It's in Authorities Bundle 4, tab 53. The case commences as MS 2184, but the relevant passage is at MS 2199 and 2200. So starting at 2199. And you'll see at paragraph 4, 5 and 6 that the Court of Appeal proceeded on the basis that those Scottish cases were considering a not dissimilar privilege. And my Lord Hodge has anticipated the point which I wish to make, which is that in addition to the issue raised by Lord Mance and Jacob Turner quite rightly in the book regarding this as a basis for the test being questionable, and of course both sides go further and agree that it's wrong because it converts a right to an appeal in one of those other categories, we also submit that there's a further reason why it's incorrect, in addition to it appearing to be inconsistent with the concept of an appeal as of right. And that's because the premise at paragraph 4 of Emerald Bay, that the position of Scottish litigants appealing to the Supreme Court is a not dissimilar privilege, is in fact not correct. There are certain key distinctions And I'm going to take you to the Uprichard case just briefly on this point, which is in the same bundle, Authorities Bundle 4, tab 48. And it commences at MS 1972, but if I can ask you to turn up 1987, please.
Sorry, what was the reference? 19?
So it's 1987.
87, yeah.
So it's the very back of tab 48 in the same bundle. It's 1987 and 1988. And that's where Lord Reid runs through how the public interest is protected in respect of Scottish cases and how it's very different to the way in which the public interest is protected by the filter for Northern Irish and English and Welsh cases. And at paragraph 61, reference is made to certain statutory rules qualifying the right of appeal, but also importantly, and my Lord Hodge foreshadowed this, at the bottom of the page, the primary mechanism for securing the public interest being the requirement that the notice of appeal must be signed by 2 Scottish counsel who must certify that the appeal is a reasonable one. And there was criticism in this case, having heard the full case, about that safeguard having failed and urging counsel to ensure that that safeguard is a meaningful one. Now, there's no such safeguard for the statutory provision that we're dealing with here. So it's not right to say in Emerald Bay that it's a not dissimilar privilege. We submit that there are differences, key distinctions between the 2 provisions. So our submission is that the Court of Appeal in this case got it wrong. We're in agreement on that. But their reasoning is understandable. It's responsive to the concerns expressed by Lords Hoffman and Hope in the case of Wilson and by Lord Reid in this case concerning the Scottish case. And we've indicated in our written case that we see considerable force in the rationale expressed in Emerald Bay and indeed here. And it's strengthened further by the fact that as long ago as 2005 in the Pareto and Kurth case, Southwell JA had invited the bailiff and the other island authorities to consider rather urgently whether leave should hereafter be required for all appeals from the Court of Appeal. So we think that the position is that they applied the test, they did not apply the correct test. The correct test is correctly stated in Pareto and Kurth. For your reference, I don't ask you to turn it up, that's at Authorities Bundle 3, tab 39, at paragraph 36. And
Page reference, please.
Apologies, I do. So I'll get you the reference. My apologies, Lady Hale. So it starts at 1723, and paragraph 36 is at 1728, and 1729, excuse me. And it's summarised in our case at paragraph 10. So there is a residual discretion in cases which are cases of abuse, or indeed, as put by my learned friend, in circumstances where the appeal is not in reality an appeal. So that's the correct test. It wasn't applied by the Court of Appeal here. Now, in relation to the Privy Council.
Well, what was the reference to Judge of Appeal Southwell recommending a change of law?
That's paragraph 41 of the same case.
Yes.
Ah, yes. Well, I'm afraid it's a thought which occurs to every new member of the board, and one would hope that it's a thought which might now be acted upon in some contexts at least, or considered by the bailiff and island authorities. It's more difficult in other countries where it often, any such thought often raises rather controversial issues about the board generally.
Yes.
But it's not a thought which has escaped the board itself, but we take the view that we can't do anything except apply the present.
Well, precisely. Although you could do, as has happened in those Scottish cases, you could include in a reasoned judgment a postscript or a reference to the concern that this remains the case. And that's particularly the case when you have 5 successive Court of Appeal cases in Guernsey, where the Court of Appeal is saying, for its jurisdiction, there's a concern about applying the test as we understand the test to apply, the appeal as of right, and where in Pareto and Kurth, over a decade ago, Southwell JA had invited the island authorities to consider this question rather urgently, and were 13 years on, and that has not yet happened. So in the event that you are giving a reasoned judgment on this point, we hope that these submissions are of assistance, because it is a matter of concern, and we raise these for the court generally. They don't necessarily affect our particular case and the impact on these two parties.
It is strange that Jersey has chosen to delete the exception which has existed since the initial enactment of the Court of Appeal Act in 1961.
Yes.
And Guernsey hasn't acted.
Yes, we very much recognise that. Yes. I'm very conscious as well, there is one other distinction which I don't dwell upon between the Scottish cases, and that is that in the Scottish cases reference is repeatedly made to the fact that Scotland stands alone within the United Kingdom in being treated in this way. And of course that's not the situation here, because there are many other jurisdictions summarised in a rather excellent table in a book available in all good bookshops by one of the panel, which sets out the number of other jurisdictions which have a very similar provision. So it's not unique in the way that Scotland is unique within the
I think when sitting as we do as the board, we're well aware
yes, we're very conscious
of those jurisdictions.
We're very conscious, and of course it is always surprising when people see the range of cases that come before you from the Privy Council and what some of the facts are and what the issues are that come before you, in contrast to the very weighty issues that come before you from the Supreme Court. So in terms of the actual
some
test...
of us quite enjoy having a bit
yes.
And perhaps...
change of diet.
A change may be as good as a rest. I can certainly see that point.
It shouldn't be understated how significant some of the Judicial Committee cases are.
Of course. Yes. I'm very conscious of that. And indeed, I've appeared in death penalty cases and in other constitutional cases raising fundamental issues. And I don't belittle that in any way. But it is important to acknowledge here that you have successive decisions of the Court of Appeal raising concerns about this provision. And it may well be that you wish to echo those concerns in a reasoned judgment when you're looking at this particular issue, despite the fact that the Court of Appeal here got it wrong. And we would also be anxious to ensure that the Court of Appeal isn't subjected to particular criticism when we say it's actually quite understandable. They were applying a settled line of authority. Now, there's no rule of precedent in the Guernsey Court of Appeal, which means they're bound by previous Court of Appeal decisions, but it's very understandable. They were fifth in a line of cases raising this same point following Emerald Bay, and it's good to hear that this issue is going to be resolved. In terms of
the issue arises equally in Investec, and
yes.
I think it's inconceivable that it won't be covered in one
yes.
or the other, at least by reference to the other.
We're very grateful, and also myself and Mr Jacobs and Mr Barnes are very conscious of our obligations to the court, and we felt it appropriate to raise this additional point about the flawed assumption in the Emerald Bay case about Scotland being a legitimate analogy. And we say, in keeping with my Lord Hodges' question earlier, it's not a fair analogy, in fact. So the actual test, as summarised in Pareto and Kurth, is that there is a residual discretion, and the way my Lord Mance has put it in the book with Jacob Turner is that it's a low threshold, but it's a way of weeding out vexatious claims. So that's how it's described. It's an exceptional circumstances test, and we very much agree with my learned friend's reference to, as an example of something which may fall into that category, an appeal which is not in reality an appeal. So you can't have a situation where, because you have an appeal as of right, you can raise a whole new point which isn't in reality an appeal. Turning to the Privy Council, and I'll do this very quickly, I agree, and I apologise to my Lord Mance for the reference earlier to grave difficulty, because in relation to the Privy Council, there are concerns about how the test is phrased differently, but I wouldn't put it in that category. It's not in any way similar to the concerns that we raise about the Court of Appeal of Guernsey and how it's approached the test that it must apply. But the test is referred to differently in a variety of ways, including in the third practice direction, and we make reference to this at paragraph 13 of our case. Paragraph 3.3.3 of practice direction 3 describes the test as being where, in the opinion of the appeal panel, the appeal has a reasonable prospect of succeeding.
Don't we touch on that in the book as well?
Yes, so...
I'm certainly been conscious of it for some time.
Yes. So that raises some concerns, and you will have seen in our case that some of the points we make, if the test is, does it have a reasonable prospect of succeeding, many of the points which my learned friend took issue with would be very relevant. If the test is a much lower one, akin to the new judicial review test of wholly without merit, for example, in jurisdiction of England and Wales, then some of those points would not be relevant. So there is a concern that the practice direction describes the test as being, does it have a reasonable prospect of succeeding? That may in part be drawing from paragraph 19 in the Ross case, which was referred to earlier, the clearly arguable phrase used by you, Lord Mance, in that case. But of course, there's different ways of reading that, about whether it was a test or whether it was simply a description of the facts in that case, that in addition to passing the threshold, it was also clearly arguable. In Crawford, which is at Authorities Bundle 3, tab 34, paragraph 23, and the reference for that is MS page 1582. The description there is that where there's an appeal as of right, it's at letter G on page 1582, where there's an appeal as of right, it would only be in exceptional circumstances, as, for example, where it was clear that the appeal was wholly devoid of merit and was bound to fail, that the board would refuse special leave to appeal or would impose conditions additional to those which the Court of Appeal is permitted to impose, in that case by the Jamaican order. And we agree that it's an exceptional jurisdiction. We think that Crawford describes it correctly by saying wholly devoid of merit is one example, but it's not exhaustive. And we agree with my learned friend that another such example would be where an appeal is not in reality an appeal. So I then turn to application of the test, and I can deal with this very quickly. I don't intend to expand on the points made in writing, which you have before you. You will have seen that if the application of the test here, if the test here is whether there's a reasonable prospect of succeeding test as described in the practice direction, then our submission is that this plainly falls at that hurdle and it does not have a reasonable prospect of succeeding. If it's a much lower threshold, essentially saying, is this vexatious, is this wholly without merit and not arguable in any way, some of those points won't be relevant. But there is one place where it is very relevant. And for that, could I ask you to turn up the record, volume 2, page 772.
Pardon me. Could you repeat the page, please?
772. This is ground 2 of 7, and it ties in with the question raised by my lady, Lady Hale, to my learned friend. So ground 2 is that the courts below ought to have held that German law governed the maintenance claim, conflict of laws point. And in summary, our position is that this is an appeal which is not in reality an appeal. I can give you the references to make that good now, and I'll do that briefly. I'm conscious that this is a topic on which it may be that you will require some time to look through the references, and it may be that you want to consider this point in a rolled-up way, as we suggest in our case, because in our submission this is precisely the type of ground which is not in reality an appeal. And when we go through the documents, I will be able to show you that. But in the short time available, you may think it better to hear it in any event and then take a view. If you do that, we want to preserve our position that this is something which shows precisely how the special leave provision should not be used. And I'll give you the references briefly now, but I intend, if you do go on to hear the full hearing, to give you more detail. So our position on this is, quite simply, the choice of law in the way that it's raised now was not argued before the courts below. It says at paragraph 41 of that page, MS 772, that the board should note that the issue of the law applicable to the maintenance claim was not clearly identified by the applicant until the proceedings reached the Court of Appeal, but it's a question of importance. In our submission, we say it wasn't clearly identified by the applicant then either. And this is, to use my learned friend's phrase, an appeal which is not in reality an appeal. Now, the applicant did argue that as a matter of fact, the parties were not habitually resident on Sark, and thus that the Sark court did not have jurisdiction. And as you know, that was rejected by the Sark court on 30th of May 2013. I don't ask you to turn it up, but the reference is at Record Volume 1, MS 126. The applicant did also argue that the legitimacy of the child should be determined with reference to German law, and that matter was resolved by the Sark Court in its judgment of 12th of September 2014. That's Record Volume 2, page 434. And the court considered, having heard evidence, that the status of the child under German law was not that of a legitimate child, and neither was he legitimate under the law of Sark, and accordingly, to that extent, it was immaterial which law applied. And it was not argued before the Sark Court that if it did have jurisdiction, the correct choice of law was other than that which applied in Sark. Now, the applicant's grounds of appeal to the Court of Appeal...
In other words, the sort of lex fori approach seems to be treated as inevitable.
Yes, we've heard that, but what I want to show you is that this wasn't properly before the Court of Appeal. Now, the reason I can see that this is difficult to do is in the short time available, you may prefer to deal with this as a substantive point and reserve your position on special leave. And I'm very much in your hands. We, as I indicated at the outset, don't want to engage in procedural point scoring, and we're quite conscious that the Judicial Committee has set aside a 2.5-day timetable. I think I can probably...
A 2-day timetable.
Yes. Well, it's 2 days with the amendment, which myself and Mr Richards and Mr Jacobs agreed, which we hope is helpful, has freed up Wednesday afternoon. I can give you the references, but I will need to return to this point in a bit more detail in the event that you do grant special leave on this point. Are you content for me to give you the references, or would you rather deal with it on a rolled-up basis? I'm content either way.
Rolled up, I think.
I think
Yeah.
we would prefer to deal with it when you come to it.
I'm very happy to do it in that way, and I think, in fact, it will be easier, because by that stage you'll be more familiar with the records. So I'm conscious I'm delving into facts when actually this is a question of law. But our position, so I can make it very clear, my learned friend is aware, in the event that you're proceeding, my learned friend is aware that our position is that on ground 2, this is an appeal which is not in reality an appeal. Could you give me a moment? Unless I can assist you further, that's all I needed to say. Can I assume that I don't need to trouble you on the issue of whether you can hear from me? I realise that's rather stable door and horses bolted, but we do have a response to the point that was made about the Form 3 and so on. I assume you don't want to be troubled by that. I'm very grateful. Thank you.
Thank you. That is not the sort of point that is of any real significance in this call.
Would you like to hear from me on the appeal?
Well, Miss Wakefield, we did talk about this, and we did think that we would reserve our position on all of the issues relating to special leave and hear the substantive arguments. As you're all here, and you've all spent such a lot of time and effort working them up, as have we, and so we would like to hear from you about the substantive arguments.
So, ground 1. The Sark Court does not possess an inherent jurisdiction to make a maintenance order, and moreover, the making of such a periodic payment order in this case falls outside the statutory jurisdiction which it does have. So ground 1 is the jurisdiction point. First of all, how does this point arise? Volume 1 of the record, on page 1, is the originating summons. And if I could take you to paragraph 5, since then the respondent has been paying maintenance, obviously at this time the respondent was the appellant and the other way around. The respondent is the father, has been paying maintenance for the child of approximately €4,000 per month without signing any appropriate legal agreement. No formal agreement has been entered into between the applicant and the respondent in respect of maintenance of the child. Paragraph 6, the applicant hereby applies to the Seneschal's Court A, for a maintenance order and a sole care and control order in respect of the child pursuant to the court's inherent jurisdiction. Jumping up to the first appellate stage, the Royal Court of Guernsey, Deputy Bailiff Mr McMahon, dealt with the inherent jurisdiction of the court in his public judgment of the 13th of June 2016. That's in the second volume of the record at page 571. So 571 is where the public judgment begins. And in paragraphs 8 through to 11, we have some of the history of the court, which I'll come to shortly. In paragraph 15, about halfway down, we see that he says, accordingly, I do not regard the role to be played by the Royal Court as meaning that the Court of the Seneschal was, within the jurisdiction of Sark, subordinate in the sense of having a limited jurisdiction derived solely from statute. Then at paragraph 24, he concludes at the beginning of that paragraph, for these reasons, I reject the appellant's contention that the Court of the Seneschal is a creature of statute, and for that reason does not have any inherent jurisdiction. A Sark court, constituted in different ways until it settled into being the Court of the Seneschal, known today, exists because Sark, although part of the bailiwick of Guernsey, is a separate jurisdiction with its own legislature, executive and judiciary. Turning further forwards in that judgment, in paragraphs 33 through to 36, we see the Deputy Bailiff consider the jurisdiction parens patriae, which I'll come back to. Then in paragraph 47, when the respondent's application said it was brought under the Court of the Seneschal's inherent jurisdiction, I regard this as a shorthand way of saying that there was no statutory provision that could be pleaded. In other words, the respondent was relying on the customary law of Sark. But then in his conclusion, in paragraph 50, just over the page, we see a re-emergence of the inherent jurisdiction. A couple of sentences in, I find that the Court of the Seneschal is not a creature of statute in the sense of enjoying only the jurisdiction expressly conferred upon it by the measures relating to it. As a consequence, there is available to those seeking access to the Court of the Seneschal some form of inherent jurisdiction that can be prayed in aid to ensure that the court is able to function properly as a court. In particular, there is a parens patriae jurisdiction available, because if there were not, the people of Sark would be forced to make use of the equivalent jurisdiction of the Royal Court of Guernsey. In my view, that is an unacceptable outcome where the people of Sark are entitled to have recourse to the only court of justice in their island. Turning to the Court of Appeal's judgment, on page 730 of that same volume, volume 2, we see in paragraph 19, the Court of Appeal sets out his conclusion in his public judgment. That's paragraph 50, the one I just read aloud to the board, in which he refers to inherent jurisdiction and the jurisdiction parens patriae. In paragraphs 29 through to 34, we see the jurisdiction concerning children is dealt with, again, by reference to the history of the court, which I'm going to take the board through shortly. The paragraphs of the Deputy Bailiff's judgment are set out, and then in paragraph 34, the court says, we agree with this analysis. And we then, in paragraphs 48 and 49 of the judgment, come back to this idea of shorthand. So 48, the father also complains that the jurisdiction to award maintenance cannot be regarded as part of any inherent jurisdiction that the Court of the Seneschal may possess. And the mother's application of the 28th of January 2013 to that court at the outset of all this litigation had referred to that court's inherent jurisdiction as the basis for the orders claimed by the mother. In our view, the answer to this point is the one given by the Deputy Bailiff in both his judgments, namely that the reference to the inherent jurisdiction was a shorthand way of saying that there was no statutory provision that could be pleaded. In other words, the respondent was relying upon the customary law of Sark, paragraph 47 of the public judgment. The Court of Appeal says that the father had taken an unnecessarily technical view of the import of the reference to the inherent jurisdiction. On any fair reading of the mother's application, the father can have been in no doubt about what she was seeking and why. Now, the reason that I've taken the board through those references is that the respondent says in paragraph 7 of her written case that the references to inherent jurisdiction are only ever shorthand for customary law. And so this point just doesn't need to be dealt with at all by the board, and our first ground of appeal fails. Now we say that's wrong. We say the summons relied expressly on the court's jurisdiction. It's the case which the appellant sought to meet, and that should be taken as face value. In the absence of any amendment to the pleadings, frankly, the appellate court should themselves, we would submit, as part of their own appellate jurisdiction, have felt bound by the limits of the summons as formulated. And we also see in the judgments below, there is sufficient endorsement of the notion of inherent jurisdiction and jurisdiction parens patriae, in particular by the deputy bailiff, that this is an issue that is live and should be considered by the board. Turning to our case, we say that the Sark court
This is an interesting argument to those of us who are used to family jurisdiction in England and Wales, where we don't have pleadings. So the idea that a matter of this importance to the welfare of a child should depend upon the technicality of the way a pleading is put is something that would surprise us.
I can see that entirely, my lady. Of course, we're dealing here with a...
It seems as if it surprised the courts below as well.
It does, my lady, but we're dealing here with a court which, if I'm right, has no jurisdiction over family matters like this.
But if there is in customary law an entitlement or an obligation on a father to provide reasonable maintenance for his child, whether legitimate or illegitimate, then does this argument matter a jot?
My lord, it would matter if... so if there's an obligation, and then the question is what cause of action or what way could it come before a court? And then the question is there a court which has jurisdiction to hear that claim?
Well, no, but if in the customary law of Sark, and you'll be coming to argue later that there is no such customary law, but if under the customary law of Sark there is an obligation on a father to maintain his child, then the Sark court would have jurisdiction, would it not?
No, it would not have jurisdiction.
Why not?
Well, I'll take you through the various statutes which establish its jurisdiction, but it patently has a narrower jurisdiction than the entire law of Sark. So, for example, you cannot bring divorce proceedings in the court in Sark. Those have to be brought in the Guernsey court. It's impossible to bring judicial review claims in the Sark court. Those have to be brought in the Guernsey
Sure.
court. So, no, those two are unrelated in my submission.
I see.
So we say that the Sark court is a creature of statute and that it is not a delegate of the sovereign and possesses no powers to act parens patriae.
I'm sorry just to revisit the question, but inherent jurisdiction and customary law are two different things. Is this a pleading point that's being taken on behalf of the father? It was put as inherent jurisdiction, there isn't any. Or is it also, the point that Lord Hodge was following up, I think, also an argument that there is no customary law in Sark either?
So those are two different points, my lady.
Yes, they are, and they're both being run.
They're both being run.
Thank you.
Yes, so the customary law point is our third round of appeal.
Thank
So
you.
basically we say, when you start looking at the court, do you have to look at the statutes which constitute it, and the statutes which define what Sark law is, or can you look outside those statutes, those documents? So step one is you can't look outside those documents. Step two is what do those documents say? What is Sark law? Is customary law locked down by l'approbation des lois? Was it able to develop in parallel? And what is its content? Yeah, but those are different points. The same way that, I hope this isn't seen as too glib an example, but for the county court here, one could say it's a creature of statute, but then obviously as a court it applies the common law. So they're two different things. And we see through the pleadings in this case, or through the documents in this case, and through some of the judgments, respectfully, an elision between the idea of, is Sark law only statutory, and is the jurisdiction of the Sark court set out by statute? But they're two different things. The statute which sets out the jurisdiction of the Sark court could empower the Sark court to consider common law. They're two different things. They're frequently elided, I think, in this case.
Could you just confirm, is divorce and judicial review in Sark, do they have only a statutory basis?
Divorce, yes. I'll check on judicial review. Sorry, I don't have an answer on judicial review. I'll come back tomorrow.
Please come back when
Yes.
you've had a chance to look.
I will.
Thank you.
If it assists, I hesitate to interrupt, but we can overnight provide a copy, if it would be of assistance, my Lord, of the section in the Dawes Laws of Guernsey text on judicial review in Guernsey, if that would be of assistance.
That would be of assistance.
We can make copies.
I remember the book.
Thank you.
Used to be the position, as I understand it, that Sark law didn't admit couples to get divorced at all. One of the parties had to move to Guernsey so that Guernsey law became applicable, and then one would apply for a divorce in Guernsey. Now Sark law does allow for divorce. The parties do not need to go and get another applicable law, but they have to bring that application for a divorce in the Guernsey court.
Yeah, that's all statutory.
That's all statutory,
Yes.
it is, my lord. So the history of the Sark court is set out in detail in paragraphs 8 to 31 of our written case. There are also various documents in the bundles which assist in this regard, as well as some of the original sources, the vast majority of which I have to say, I'm afraid, are in French, often with no translations, as you may well have seen already from looking at the bundles. We also have two commentaries, one in French and one in English. We have Ogier, the Government and Law of Guernsey, which is in tab 67. We don't need to turn that up now. And also Ave, les Cours Royales des Îles Normandes, which is at tab 65. In essence, and I'm now summarising those sources, taking this as well from my written case, although the island had previously been populated and previously had a court, it seems to have become depopulated and indeed deserted by the 16th century. The uninhabited island was granted to, and I apologise for my pronunciation here, Elie de Carteret, or Carteret, I don't know how one says that nowadays, by letters patent of 1565 and a royal charter of the same year, which, among other things, granted the seigneur the right to a manorial court. By 1579, Jerseymen had repopulated the island. They purported to set up their own court, applying Jersey laws, customs and rules. That court was abolished as a result of action taken by the Royal Court of Guernsey. And it's in that context that Her Majesty made an order in council dated 24th of April, 1583. That's in the first volume of our authorities bundle, tab 1, MS 790. Now, you'll see it's a fairly difficult to read document, this. In fact, the proper name for what's behind tab 1 is the second report of the Commissioners for Inquiring into the State of the Criminal Law in the Channel Islands, 1848, but it has a lot of the original materials in it, and I think that's why it's been included in the bundle. So if we go to 790, you can see there are numbers occasionally on the left-hand side of the page, and we're at 5729. Ordre, loi et usage appointé et commandé. That's how it starts. And the first recital, or considerant, is a description of the controversy between the Jerseymen and the Royal Court of Guernsey, which has led to this order in council being made. Article the 2nd says, for the civil jurisdiction in Sark, we think it convenient that there be 5 jurates chosen by the inhabitants of Sark, unless the people, increasing, shall require a greater number. Then, by Her Majesty's order, to be augmented to 7, and the eldest of the said jurates to give sentence, as is used in Alderney. Article the 3rd, the jurats to hold pleas and use jurisdiction in Sark in all causes, as is used in Alderney, and appeals likewise to be from Sark to Guernsey, as to the superior justice in all causes, as is in Alderney.
So,
Then to the
Ms.
7th.
Wakefield,
Yes.
as is used in Alderney, are you going to help us about the jurisdiction in Alderney?
I'm not, my lord, because later when we get to 1931, you'll see that the Royal Court in Guernsey was given the power to dictate the jurisdiction of the Sark Court. And so we have a specific ordinance at that point, which makes no reference to Alderney.
But Alderney is part of the bailiwick of Guernsey, isn't it?
It is, and it may well be, but I'm purely speculating that similarly the Royal Court of Guernsey sets the Alderney Court jurisdiction. I have no idea. I can research overnight if it would be of assistance to the board.
Well, if this brings in customary law, and if it brings in customary law as used in Alderney, I'm slightly surprised that you're not educating us about that, Ms. Wakefield.
That's not here when we're talking about jurisdiction, my lord. It's in the later articles when we talk about l'approbation.
It's Article 15, obviously.
Exactly.
Well, we're coming to that.
We're
Article
coming
3rd
to
is the jurisdiction, Article 15 is the
the
applicable law.
Exactly.
But the same point arises.
Well,
The
the
ancient
same.
laws and customs confirmed to be established by Her Majesty as in Alderney.
Well, the same point does arise, say, that I can immediately educate the board on what happened in Alderney. L'approbation happened. It's the same approbation across the islands.
Throughout the bailiwick.
Throughout the bailiwick, but of course, elsewhere without this order applying to it. This order in council is Sark specific, and that's what we rely upon for the first of our various points under customary law, namely that this prevented any subsequent development of the customary law. But there are numerous other grounds that we rely on under that ground of appeal. So we looked at Articles 2 and 3, and please do tell me if I haven't adequately answered your question. Article 7 says, for ecclesiastical causes, we think good not to meddle therein, but to refer that wholly to the Bishop of Winchester, to whose jurisdiction all these isles are annexed. And of course, as part of ecclesiastical causes, one would have had, not divorce then, but everything matrimonial. Article 15th, that in Sark the inhabitants shall observe the ancient laws and customs confirmed to be established by Her Majesty as in Alderney. Article the 16th, touching ordinances or bylaws to be made for matters within the island of Sark, we think it convenient to refer to the Lord and the inhabitants of Sark from time to time as they shall see necessary for the welfare of that isle, until your LL, your lordships, I imagine, upon a special complaint shall see cause to take other order. So those are the critical articles of that order in council of 1583. Further down that same page, you'll see pet first, pet the second. Those are the petitions, and then petition the third. And this is a petition from Philip de Carteret, saying, thirdly, that there might be a seal identical granted by Her Majesty within the said isle to serve in causes of common justice arising within the same between party and party. And that's responded to below. This is rep the first, rep the second, rep the third. And the matter of the third petition was denied as not expedient to be granted. So no seal authentical was granted to the court. The Sark Court, envisaged in Article 2, was then established by an ordinance of the Royal Court of Guernsey in 1594. That's just down that same page at the number 5730. Now, I'm afraid this is in French, and we have no translation in the bundles that I'm aware of, at least. But I draw your attention in particular on that first page, just so we can see the link between the two documents. It's 5 lines up from the bottom. Il aurait une juridiction et officier établie pour l'administration de la justice et police de la dite île, comme est portée par l'ordre sur ce fait à Greenwich, and then we have 1583.
Sorry, which page was this on?
791.
791.
The page.
Oh, no.
And it's 5730. I'm sorry it's so difficult to work through these documents. But
Yeah, no, I've got it. No, I've got
Yeah.
it. Yeah.
So we see, again,
got
so in that
confused,
first
right.
section, the recital, the considerant, they're linking it back to the Ordering Council of 1583. And then over the page, we have premier, and then in the second paragraph, we do have a translation for this in our written case in paragraph 24. It starts on administration de justice, and that's translated in our case as the laws and customs. So I'm starting, from des lois et coutumes. The laws and customs approved and established by the authority of Her Majesty in the said island of Guernsey, which conforms with the laws and customs of Normandy and with the local customs of the said island of Guernsey, which have been approved, differing from the custom of Normandy.
Shall be used in the administration of justice by the said jurats, or
Exactly.
jurés, des lois, whatever that means.
Yes, my lord. And then the next paragraph, so that's applicable law, if you will, the content of the law. And then the next paragraph says that those jurats, the jurés, will judge toute cause civile, tant en cause de meubles que d'héritage. And again, the translation, paragraph 24 of our written case from a book called The Fief of Sark, is all civil actions concerning personality and realty.
Heritage is confined to realty, is it?
Yes, in the translation given in our written case at least. Yes.
It's more likely to be the distinction between movables and immovables in Roman law.
Yeah.
And indeed, that's what we come onto in the later documents, meuble et immeuble.
Or Roman French law.
Now, we'll be coming back to what's meant by the approbation later under ground 3 and customary law. But we say that Article 15 of the 1583 order and that reference in the 1594 ordinance to Her Majesty approving or establishing customs is a reference to the document called the Approbation des lois, coutumes et usages de l'île de Guernsey. We have that behind the next tab in the bundle, MS page 795 onwards, and we'll look at that extensively tomorrow. That's a document, in effect, which was completed in 1582. It was approved by order of Her Majesty's Privy Council on the 27th of October 1583. Essentially, it describes the customs of Guernsey by comparing them with the general customs of the Duchy of Normandy, as were recorded in Terrian's Commentaire du droit civil, ton public et privé observé au pays et Duchy de Normandie. So you'll see you have Terrian's description of the customs of Normandy, and then there's a document before that in the approbation saying, yes, this one is part of our law, that one's not part of our law, this is how we do it differently, that sort of thing. We'll come back to that tomorrow. Now, a further order in council was made around 100 years later on the 19th of May, 1675. That's at number 4855 in the little numbers, which is MS page 787. And this is the order which replaces the jurats with the seneschal.
That's because they wouldn't swear the oath.
They wouldn't swear the oath, exactly. And it says here, the island hath remained for above a year without any administration of civil justice, to the great prejudice of our subjects there. There's then a 1675 Act of the Royal Court of Guernsey, that's 5733, which is MS 793. Which affected that change and made the seneschal the court. So you're at 5733, again, I'm afraid this is in French, and in the first substantive paragraph, 1, 2, 3, 4, 5, 6 lines down, it says that ces charges de sénéchal pour exercer avec même pouvoir et autorité de juridiction que les naguères juges et jurés de la dite île. So the seneschal inherits entirely the same jurisdiction as the jurats previously exercised. So for that reason, we think that a better interpretation of the change from jurats to seneschal is that it's simply a continuation of the same court. However, if we're wrong in respect of that, and a new court was established in 1675, we say, again, it was a court established by statute, much as the 1583 court was. We then leap forward through time to 1922. A new order in council was made. This is behind tab 5 in Authorities Bundle 1, at MS page 827. And in Article 13...
Can you give me the page again, please?
So it starts 827.
Thank you.
We're going to look at Article 13, which is on page 835. And that says that the seneschal shall be the sole court of justice in the island. There shall be an appeal therefrom to the Royal Court of Guernsey, and the said Royal Court shall determine the jurisdiction to be exercised by the seneschal's court in civil and criminal matters. So, my lord, that's the reference I was referring to earlier on, where the Royal Court in Guernsey was given power to dictate the jurisdiction of the seneschal's court. We say that in itself shows that the court has no inherent jurisdiction. In 1931, an ordinance of the Royal Court...
Shall determine the jurisdiction to be exercised. Does that mean shall decide what jurisdiction is exercised, or shall determine the existing jurisdiction? Which is it?
Sorry, I don't understand the question.
Shall determine the jurisdiction. Does it mean shall decide what the jurisdiction is, or does it mean shall perceive what the jurisdiction is?
It might help if we look at the 1931 ordinance in which the Royal Court did what they thought they were being told to do, and then we'll see.
I see. Very well.
Yes, the question is really, have they got to do it in advance? Or the Court of the Seneschal having done something, is it okay if the Royal Court says that's okay? That's basically the question you're asking.
So I'm not sure what happened in the intervening period, but in 1931 they said it in advance, if I can adopt that terminology. So that's behind tab 7. That starts on page 849. Again, it's in French, I'm afraid.
Which one? Sorry, 849, yes.
849, yeah. Over the page, on page 850. You see in paragraph 1, that's the right way to refer to it. La Cour du Sark aura le droit d'entendre et de juger de toute cause, soit en meuble, soit en immeuble. Then we see the movable, immovable distinction. So long as there is an appeal to the Royal Court of Guernsey. And that jurisdiction was repeated in subsequent relevant legislation. In 1951, in the Reform Sark law, behind tab 8, section 23, which is MS 862, says the Court of the Seneschal shall be the sole court of justice in the island with the same jurisdiction in criminal and civil causes as heretofore. So there, my lord, we see a change away from the Royal Court of Guernsey, possibly on some reading having an after-the-event jurisdiction, and now we see that the extant jurisdiction is simply being confirmed, the same jurisdiction as heretofore. And then in 2008, behind tab 11, section 10, which is on MS 939, extent of civil jurisdiction. The civil jurisdiction of the court comprises all matters other than criminal matters, A, in respect of which the court had jurisdiction immediately before the commencement of this section, and then B, which are assigned to it by this law or by any other enactment. And of course, we say an example of such an enactment is the 2016 Sark law, which gives it jurisdiction to make the equivalent maintenance payments, periodic payments. So to conclude that overview, we say that the Sark Court was a new judicial entity established by the 1583 Order in Council and the 1594 Ordinance. And we say that the Royal Court and the Court of Appeal were wrong to find that it was a continuation of a pre-existing court. The juridical space, if I can put it that way, was empty following the abolition of the Jerseymen's Court. The 1675 order granted to the Seneschal the same jurisdiction as had been exercised by the jurats. And the modern court looks to the 1931 ordinance given by the Royal Court of Guernsey, granting the Sark Court jurisdiction in respect of meuble et immeuble, which jurisdiction is then confirmed by the 1951 and 2008 Acts. And we say simply that the Sark Court has only that jurisdiction. It has the jurisdiction given to it in the various instruments. It has no more inherent jurisdiction than the county court. Turning to the specific kind of jurisdiction, which was relied upon below at length by the deputy bailiff, and we would say, my ladies and my lords, in response to the earlier comments, we don't see that it's simply a pleading point. It was something that was explored at great length in these earlier judgments. And we say that the Sark Court simply doesn't have a parens patriae jurisdiction, because that is a jurisdiction which a court exercises as a delegate of the sovereign. A court which is a creature of statute does not have that power, and a court which does not have a seal authentical does not have that power. I don't want to teach you all to suck eggs, but of course, parens patriae jurisdiction is a jurisdiction to exercise the sovereign's protective role in relation to children who are her subjects, and it springs from the quasi-parental relationship between the sovereign and her subjects who are children. I'd like to quickly turn up, if I may, A and A, to look at the words of my Lady Hale. That's in Authorities Bundle 4 at tab 49. It's paragraphs 60 to 61, MS 2013. So at 60, Lady Hale says, we've already established that the prohibition in Section 2 of the 1986 Act does not apply to the orders made in this case. The common law rules as to the inherent jurisdiction of the High Court continue to apply. There is no doubt that this jurisdiction can be exercised if the child is a British national. The original basis of the jurisdiction was that the child owed allegiance to the Crown, and in return the Crown had a protective or parens patriae jurisdiction over the child wherever he was. As Lord Cranworth explained in Hope and Hope, the jurisdiction of this court, which is entrusted to the holder of the Great Seal as a representative of the Crown, with regard to the custody of infants, rests upon this ground, that it is the interest of the state and of the sovereign that children should be properly brought up and educated. And according to the principle of our law, the sovereign, as parens patriae, is bound to look to the maintenance and education, as far as has the means of judging, of all his subjects. Then in paragraph 61, Lady Hale confirms that the continued existence of this basis of jurisdiction. The Royal Court of Guernsey also referred to the judgment of Lord Sumption in Re B, which we don't have in the bundles, but I can take you to that bit of their judgment. It's the second volume of the record at page 583. And Lord Sumption in paragraph 81 simply says, the inherent jurisdiction of the High Court with respect to children originated in an age where the civil courts had no statutory family jurisdiction. It is based on the concept of a quasi-parental relationship between the sovereign and a child of British nationality. And we say simply, as I've said already, the Sark Court does not exercise that sovereign power, that prerogative power. For those reasons, we say that the Royal Court was wrong to hold and to conclude in paragraph 50 of its judgment that it was exercising such a jurisdiction.
By what means did the High Court obtain the jurisdiction, which has its origins in the Crown and in allegiance to the Crown?
Might require more historical knowledge.
I believe I know the answer to that question, but the gentleman behind you also thinks he knows the answer to that question.
Might I answer that question tomorrow once I've done a little research, my lady?
Well, you can understand why I'm asking it.
I can. I can, of course I can. But equally, of course, the distinction between a court which is a creature of statute and the court of inherent jurisdiction is one which is well known. I'm not sure how the courts which are of inherent jurisdiction are established. I suppose that's the question. And that's what I need to look at overnight.
No, the question was, the High Court in England and Wales has the jurisdiction which derives from the Crown's powers as parens patriae, and responsibilities as parens patriae over those who owe the Crown allegiance, and some others, those who are present here for a start. That's the most usual ground of it. But by what means did the Crown confer that jurisdiction upon the High Court?
Isn't that something to do with the Lord Chancellor sitting in the Chancery Division as the representative of the Crown?
Having the Great Seal. Exactly, and that's what I'd like to look at overnight, and that's what I think the answer is. And indeed, that's one of the reasons why I read the paragraphs I did from A&A. But assuming that those paragraphs don't provide the answer, otherwise my lady wouldn't have asked the question, I just need to check.
Oh, no, I might have asked the question even if I thought I did know the answer, as I told you. You get at the argument.
My understanding is that it's by virtue of the Great Seal, which is held by the Lord Chancellor and the equitable jurisdiction.
So, of course, the Court of the Seneschal doesn't have a seal.
It has no seal. It asked for a seal, but didn't.
Still less the Great Seal. That's the argument, is it?
The argument. So turning then, if I may, to the true statutory jurisdiction of the court. The subject matter jurisdiction of the court in civil matters is set out in the 1931 ordinance, to which we've already had regard, which was made pursuant to the 1922 order in council. It's carried forward by the 1951 and 2008 acts. So the 1931 ordinance gave the Sark Court jurisdiction in toutes causes, soit en meuble, soit en immeuble. That is materially identical, we say, to the 1594 ordinance, giving jurisdiction originally on toutes causes civiles, tant en cause de meuble que d'héritage. And we would respectfully adopt Lord Hodges' point that héritage and immeuble probably have very similar meanings. What does cause en meuble mean? If I might take you to the public judgment of the Royal Court, that's in volume 2 of the record at page 578.
Sorry, what's the page reference?
578. So that sets out the 1931 ordinance in paragraph 20. And then at the bottom of paragraph 20, he says, guidance on what are meuble and immeuble can, I think, be derived from the Royal Court's ordinance made on the 19th of January 1852 at the Christmas Chief Pleas, entitled Des biens meubles et immeubles, which includes at item 20, sont réputés meubles les obligations et actions qui ont pour objet des sommes exigibles ou des effets mobiliers. Now, the translation is given in paragraph 39 of our written case as obligations and actions which have as their object enforceable sums or movables. I should say that that definition of what meuble means or what it includes is taken from the French Civil Code of 1804, which we also have in our bundles, behind tab 54. I'll take you to the ordinance because I've not taken you to it directly. That's in tab 3 of volume 1 of the authorities bundles. And we will, of course, this is MS 820. We'll be coming back to this when we get to conflicts. At point 2 on page 820, we see les meubles suivent la personne. So that's what we're coming back to in respect of conflicts. And then 2 pages later, paragraph 20, sont réputés meubles les obligations et actions qui ont pour objet des sommes exigibles ou des effets mobiliers.
Sorry, where was that?
So that's on MS 823, and that's Article 20. Now, there are, around there you'll see there are other things which fall within meuble, but the Deputy Bailiff relied on Article 20, and we say he was right to do so. We say that's the closest you get to an action in maintenance, but we say it does not include an action in maintenance, certainly not the one that was entertained by the Sark court. So we say a somme exigible is an amount of money.
Well,
Which is
why wouldn't it, if there is such an action? I mean, it's a bit circular, but if you look at top of 821, movable seems to be extremely broadly defined as including a horse and a robe and money or other inanimate things. Is that right?
Yes, my lord, but not a claim for a periodic payment of money.
Well, I mean, if there is such a claim, why wouldn't it be a meuble? Isn't the question a bit circular?
Well,
I mean, meuble doesn't presumably define the whole of the law of obligations.
it does define the jurisdiction of the Sark court, though, unless it's immeuble. Because the jurisdiction of the Sark court for civil matters is meuble or immeuble.
Yes, but to assume it imposes some sort of straitjacket on the things which can develop seems to put the cart before the horse.
I mean, if there is an obligation on the father to aliment his child, then there is a right, either on the part of the carer of the child or the child itself, to which is the other side of the coin, to enforce that obligation under the law of obligations by making a claim for such aliment. Now, why is that not within the scope of meuble if the customary law allows, provides for that obligation?
There are ways in which it could be within meuble if it was for property, for food or for something that existed, or if it was for a set sum and some of the other applicable laws.
Why do you say a set sum?
Because
I mean, if there's an obligation to give reasonable aliment, which will have to be determined by the circumstances of the case, why would that not be meuble?
Because we know that meuble means somme exigible. It means an amount of money you can sue for that you know in advance.
Well, you see,
Well, you can sue for a sum to be fixed.
But it's not exigible.
It's only exigible once it has been ascertained.
It is,
Is that
exactly.
the argument?
That's the argument, my lady.
But 20 isn't a definitive definition anyway. It simply says are to be regarded as meuble the following.
That's true, my lord.
Obligations and actions which have for their object des hommes exigibles ou des effets mobiliers. So,
This is all
Yes.
about distinguishing what's a movable and what's an immovable.
yeah.
precisely.
Anyway, it depends on en pour objet, what that means as well, doesn't it? It means, does it fix on the thing that's existing now, or could it be a longer-term objet?
We say it would fix on things existing now, otherwise exigible would add nothing. So the word exigible must mean something. It must be distinguishing some exigible from soms which are in some other sense inconnu or yet to be determined. And if the import of the whole meuble immeuble distinction was, as my Lady Hale suggests, simply to distinguish between those two buckets, it would be quite strange if sums yet to be quantified became real property, immeuble, which is the only other available bucket.
It's the counterpart of the obligation, the right.
It'd be pretty strange if the jurisdiction were, for once and for all, limited to ascertained amounts.
My Lord, I would suggest it's not strange when you have another court, the Guernsey court, which sits in parallel as a court of first instance. My Lady Hale remarked on this in her judgment in the second Barclays case, that can hear everything that falls out of this jurisdiction.
Well, I thought that was open to doubt, because it might be that the Guernsey court would refer to the Sark law.
It will refer to the Sark law, but this is jurisdiction.
I see, it just goes to jurisdiction.
This says nothing about where Sark law.
But there wouldn't be a
Sark law
relevant
is.
provision of Sark law, would there, by definition, if it wasn't a meuble? Anyway.
Yes, there would be. It's very important, this point, my Lord, that the content of the law is scarcely informed in this context by the narrow jurisdiction that has been given to the Sark court. My submissions are that the Sark court is like the county court or a specialist court or a court that the Royal Court of Guernsey, we've seen, establishes. The Royal Court of Guernsey thinks, oh, what do I want to consider and what will I allow Sark to determine for itself? And it said, well, in matters to do with meuble and immeuble, you deal with those, so personal and real property, but anything else, an action for damages to be quantified at whatever level, you come to Guernsey. It doesn't tell you anything about the content of Sark law or rob anyone of their rights to have their claim litigated.
So is it your position that the court in Sark has never had a jurisdiction and has never exercised jurisdiction where an employee, as a result of the negligence of his employer, breaks his wrist, for example? You say that has to go to Guernsey?
I can't say what has or hasn't happened, but my submission is that that would be wrong if the Sark court had exercised that jurisdiction.
Yes.
Can I just ask one other question, which you can think about overnight, but just goes back to your original assertion that there wasn't any question of this court having a barons patriae jurisdiction through the involvement of the Crown. Now, we know that there was a seal authentical asked for and refused, but does that really mean that this isn't, in some measure, a royal court? I mean, the whole purpose of the Order in Council, which originally constituted the jurats in 1583, was to give effect to our wishes, in other words, Her Majesty and Council's wishes.
About that overnight.
No. I'm just looking at pages 790 and 791. Yeah.
You're basically saying that the jurisdiction is simply to enforce debts.
I am, my Lord.
And it's not in respect of unliquidated sums, that's what you're saying.
That is what I'm saying, my lady. And, of course, the Seneschal is not a legally trained person. It's a lay role with no legal
Well, that's of no relevance at all. Maintenance has been quantified by lay magistrates in this country for a very long time. The idea that a lay person can't do that.
That wasn't my submission at all, my lady. It was that when the Royal Court in Guernsey is deciding what should be determined in different jurisdictions, it set up who should be appointed as the Seneschal. And indeed, in some cases, a Lieutenant Seneschal can come in and give judgment on other matters. And when the Royal Court in Guernsey can determine who holds that post, whether they're legally trained or not legally trained, and I fully take your point that you could quite possibly say a person doesn't need to be legally trained to hear a professional negligence or PI claim to quantify damages. But the decision's been made. The Seneschal judge should not be a legally trained individual and is not assisted, as I understand it, by a legal advisor. And that might say something about some of the matters that are reserved to them. I'm not saying that they can't deal with family matters extremely ably in a day in, day out basis.
I wonder how important that might
have.
I wonder how important that might have been a few centuries ago. You would have found yourself in front of a board, I think, largely of laymen,
course, but we are
Until
dealing
200 years ago.
Of course, we're dealing now with the 1931 ordinance in particular.
Yes, good point.
And of course, with the subsequent laws, although they preserve the same jurisdiction, they do set out how the seneschal is appointed, for example, by the seigneur, two others assisting.
Well, Miss Wakefield, we've got to the end of the afternoon's hearing. By my calculation, you should be ending, were you to retain the same allocation of time as on the original timetable, you should be ending by the short adjournment tomorrow. It may be that you don't need to go on quite as long as that. It's up to you. But we'll look forward to hearing from you again at 10:30 tomorrow morning. Court is now adjourned.